Hello, everyone. Good afternoon. Welcome to the April webinar. Sorry, guys, I'm already having issues with my PowerPoint. This month, we're talking about wrap-ups, risk reduction schemes that complicate case handling. Welcome. If this is your first time, thank you for coming again. If you followed me in the past months, over the past year and a few months, I've been doing these monthly. For those of you who are here for the first time, my name is Tashia Rasul. I am a partner here at LOIS Law Firm. I oversee the construction defense practice group. This is the group where the attorneys and paralegals handle only construction claims, that is workers' compensation claims that arise out of construction accidents. One of the things that we do and that makes us a specialized group is that we work hand in hand and very closely with the general liability defense attorneys to facilitate a joint defense. So welcome. I hope you find my webinar very interesting. This is a live webinar. In the end, you'll be able to ask questions and I will provide the answers. If I run out of time, I will be sure to send you an email with your answer, or we can even chat about it. So what are we going to discuss today? We are going to talk about wrap-ups. They're OSIPs and CSIPs. We'll talk about the anatomy of wrap-ups, benefits of wrap-ups, coverage issues that arise, unique defenses and issues, and administration and important documents that we need to defend these claims when it falls under a wrap-up policy. Okay, like I mentioned, it is a live webinar. You'll see this little box, I think, on your right-hand side of your screen. You can type your question there. They'll pop up in my end, and I will answer them live. All right, so let's get into it. What is a wrap-up policy? Now, here in my office, we are often throwing around the term OSIP. This is because 99% of the cases, the construction cases that we handle, have an OSIP type of wrap-up policy. When we go to the board, the judges, the board panel, they all refer to them as a wrap-up policy, which is the correct terminology, right? Wrap-up policies refer to a type of policy that is site-specific, covers specific kind of work, and is just for a closed period of time. And there is OSIPs, and there is a CSIP kind of wrap-up policy. The OSIP is the owner-controlled insurance policy, and the CSIP is the contractor-controlled insurance policy. Like I said, the majority of the cases that we handle are owner-controlled, so I might be using that term more frequently in this webinar, but know that I'm still talking about wrap-ups in general. Now, the wrap-up policy, we're talking about one policy for a particular employer, but it covers multiple employers on the job site. It covers workers' compensation, general liability, sometimes other kinds of coverages are included, but for our purposes, we're going to talk about the workers' comp and to a certain extent the general liability coverage because that's what we deal with. They cover a particular employer, but they have to be enrolled in the project, and we'll talk about that a little later in the webinar. And they also cover a specific site. So it may cover, let's say, John Smith Construction. It is not for John Smith Construction that is doing work all across New York State. It's only for John Smith Construction that's doing work at a particular location. Are we talking the name of a location? You know, it could be a school's being built or some kind of like a commercial buildings being built. But we're also talking about specific parameters, you know, the street and the avenue, and nothing outside of those being covered by the policy. Okay, so the OSIP and the CSIP, like I just mentioned, and these are different from the operational policy. So the term that's usually thrown around in court is general policy, but the proper terminology is operational policy. This is the one that every employer needs in order to function or operate in New York State. It's the one that covers their day-to-day activities. So even like us here at LOIS Law Firm, we have a workers' compensation policy for regular day-to-day operations, and that's called the operational policy. When a contractor is properly enrolled in a project and the OSIP or the CSIP or the wrap-up covers them. Their operational policy does not come into play when there is an accident that falls within the parameters of the wrap-up policy. And this is something we're often hashing out in court. It comes up when we're alleging that the kind of activity that the employer was doing on the job site is not covered by the wrap-up policy. All right. Benefits of a wrap-up. So wrap-ups became popular in the early 2000s. They started with large residential projects, and they've moved on to more commercial projects. We've seen a lot of like public entities are using them for their projects. And the main reason there was a shift to creating wrap-up policies is to reduce risk to the owner or to the general contractor who is taking out the policy. It is great to help save money. One of the things you've noticed in my webinar every month, I talk about how to reduce exposure under these wrap-up policies, under the OSIPs. That's one of our goals, right? Construction is expensive. Accidents that arise in construction job sites can lead to very high exposure because they oftentimes result in neck and back injuries or like traumatic brain injuries. Whether they're real or not, I mean, that's a discussion for a different day, but the exposure is usually high, and it can be very costly to the employer at the end of the day, and the wrap-ups could help to save money in that regard. So there's also a reduction in litigation costs. Now, for example, a very easy, basic example would be subpoenaing the prior records. If it's done on the workers' compensation side, it doesn't necessarily need to be done on the general liability side of things. That saves the carrier or the owner litigation costs. Investigation is usually done on one side and shared on both sides. That is something that also helps with the reducing exposure in your cases. It also prevents gaps in coverage. So the wrap-up policy is set for a particular period of time, and it guarantees coverage for the entirety of the project. Now, if the employer, let's just say the employer, the contractor, is required to have their own insurance, you run the risk of there being a gap, right? Whether it's for a cancellation or a non-renewal, and then an accident occurs on the job site, and who's liable at the end of the day, right? The wrap-up prevents this gap from occurring because the wrap-up program knows how long the project is expected to last. As it's coming on to the end, there's like an automatic renewal, so there's always coverage. Efficient claims handling. So especially with the OSIPs, it's a common owner. Even for the CSIPs also, where there's a general contractor, excuse me, there's usually one insurance carrier that's writing the policy, one TPA that's administering the policy, and everyone is communicating, of course, within HIPAA regulations about what's going on in the case. And this is like the back end of how we coordinate defense between workers' comp and general liability, okay? But, so everyone knows what's going on. Your workers' comp attorney knows what's going on. Your workers' comp adjuster knows what's going on. Your GL defense attorney knows what's going on. And your GL adjuster is also aware of what's going on. So it really helps to prevent duplication of efforts, duplication of like strategy, and saves time because everyone's always on the same page. There's also, the overall and the most important benefit of a wrap-up is reduced risk through a uniform safety handling program. So all of my wrap-up clients, the ones that I work with, when they create the wrap-up, there's usually a safety protocol that's in place. It's anything from, who to call when there's an accident, where to go, what to do, who to report it to. There's also a set investigation company that's assigned to a particular project. So as soon as there's an accident, we know to call them. They go out on the scene. It really it really keeps everyone on the same page, and that's why it's really important. And for the reasons I just mentioned, it really prevents duplication of efforts and cost, and helps to reduce exposure. All right, so who's covered under this wrap-up policy? I mentioned like the contractor, the employer that the claimant would work for, but there are some things that we need to know. So if the contractor is not enrolled, they wouldn't be covered. What does this mean? In order to do work on a project, a contractor would have to sort of fill out an application and send it in. They have to be approved by the wrap-up program. And then when they're approved, there are parameters of the approval, right? So the date that they're going to be on the project, the date they're going to leave the project, and the kind of work that they're going to do on the project. Now, there are going to be non-enrolled contractors on the job site. It happens, and it's because the wrap-ups don't always cover everything that's being done on the job site. Examples: if the contractor is there for under a certain number of hours, they likely will not be covered in the wrap-up. It's usually if they're there for just 1 day to do some small job, they're probably not going to be covered. If it's under a certain contract value, it probably wouldn't be covered. Again, if they're there for 1 day and it's $1,000, they're just going to get paid to get on there, do the work, and leave. Hazardous materials, hazardous waste is generally not covered in wrap-ups. I'm yet to see a wrap-up that covers things like asbestos removal, and it's really because of the high exposure and the risk of this kind of work that wrap-ups don't want to, take that risk. So in a situation like that, if a company is brought on to the job site to do asbestos removal, that's something we should think about, that they're not covered under the wrap-up, and that immediately triggers a coverage issue. Demolition generally is not covered either. I've seen maybe just 1 or 2 wrap-ups that cover demolition, but typically it's not. And so remember, with a wrap-up policy, the broker, the insurance carrier, the owner, everyone who's putting together the policy can actually determine what's going to be covered and what's not going to be covered, and evaluate it against like their potential risk and how much they're willing to spend in terms of like covering the risk. Okay, so what's one of the complications that arise in defending wrap-ups, right? It's coverage. Coverage issues come up all the time. So in the beginning, I mentioned the difference between a wrap-up and the operational policy. This is usually one of the issues that come up. Many people make the assumption that all of the work and contractors are covered. This is wrong. Like I mentioned, if you're not enrolled or a certain kind of work is not covered in the wrap-up. Something else we have to look at is the actual date of loss. We've seen really weird cases where the claimant, and these are like bogus cases anyway, where the claimant is alleging that the accident occurred like the day after the project ended, or like day before the project started, but they so happen to have been on the project in such close proximity to that date that they're just like, oh, we're just going to throw a date out there. Then investigating, we learned that the claimant was, not on the project in a particular date, or the project, that phase hadn't even started. Like you see weird kind of stuff like that with the coverage issues and wrap-ups. Also the phase of the project, like after demolition, there's like a multiple different kinds of like phases. It's a living organism, construction sites, and while the wrap-up policy, the program knows when a particular phase ends, the claimants don't always know when they end, and sometimes claimants are there for multiple phases. So they may be there for, let's just say the erection of like steel beams on the project, and they were there, and the work was covered and the employer was covered, but then that phase ended and they remained in the job site to do something that was not covered, and the accident occurred during that period, it would not be covered by the wrap-up. All right, so these are a couple of factors that come into play when we're talking about coverage issues and wrap-ups. How do we resolve these issues? So we need all of the documentation that we can get. Certificate of coverage. This is usually like a one-sheet document that gives us snapshots of who the carrier is, the coverage period, the project that's being covered. Sometimes it's 2 pages long, but it's generally 1 page. It's also referred to as the deck sheet or the declaration sheet. We always request that. It's good to have, but the full policy is also like better to have because it has all of the details and the parameters. Sometimes it describes a description of the work. It describes the work type and the location type in more detail than the declaration sheet. The policy manual. Every wrap-up program has a policy manual that lays out the purpose of the project, who's going to be in the project, the phases, the kind of work that's going to be done in the project, how to apply to be enrolled in the project, all of the information regarding the safety program. Everything that one needs to know about the particular project is going to be in the policy manual. And here also is where we're going to see information about the kind of work that's covered and not covered. And this is important because it's not always spelled out in the actual policy. In fact, underwriters usually tell me it's in the binder, it's in the policy binder, but the policy binder is never produced to us, and we're not able to provide it in court. So we're always talking to underwriters about telling us what exactly is covered, not covered, but the policy manual would have this information also. So we should always get it. That's really the terminology that's being used. If you're an adjuster, ask your wrap-up administrator to get a copy, and I think your attorney should always have a copy. Any kind of project completion documents. From things like a simple punch list showing, it's towards the end and that we're going through all of these things on a particular day when the claimant was there or not there, or any kind of agreement that shows final payments issued, invoices, and so forth. Anything that shows that the project was completed and the last day of work that was done on the job site. The parameters of the project site covered by the policy. This is not always in the policy. In fact, I've never seen them in the actual policy. I get this information from the wrap-up administrator or just the adjuster who would know the information. A lot of times you kind of have to dig for this information, but I think the best source is your wrap-up administrator because they know the exact parameters, right? So for example, we're building this new commercial building. We know it's between 2 particular streets or 2 particular blocks and the avenues. So we know that any accident that happens outside of those parameters wouldn't be covered by the policy. Scope of work covered by the policy, that's usually included in the policy. And one of the things we've been seeing in policies lately, which is amazing, and I think the underwriters are doing a good job with it, is to clearly state in there that any accident that occurs off the job site is not covered by the policy. This is important because there are certain accidents, certain accidents under the going and coming rule or the authorized coffee break or lunch break that would be covered in normal situations, even though they happen off the job site, but we've been successful in defending against these because the wrap-up specifically says the accident has to occur on the job site, within the 4 walls of the job site. And in those particular cases, we've seen the operational policy being found liable for the accident that occurs off the job site. So it's really important to know the scope of the work covered by the policy. Well, we talked a little bit about the date, location, the exact activity that's being covered. are being carried out at the time of the accident also. Sometimes we don't get all of this information, but if I had to choose the 3 things that I need to defend every single coverage issue, it would be the certificate of coverage, the parameters of the project sites covered by the policy, and the scope of the work that's done. I would say those are the 3 most important things that I need to defend any coverage issue. Okay. Oh, I spoke ahead of my slides. What else is new? All right, so there are 4 things here: the policy, the certificate of coverage, the policy manual, and the enrollment documents. The enrollment documents I forgot about when I just spoke about them. All right, so let's move on. The next complication that we see are the parties to a wrap-up policy. So let me tell you, when I first started doing these many moons ago, and I look at the policy manual and I see all of these parties and names, I'm like, holy smokes, there's really a lot of parties to a wrap-up. So many moving parts. But listen, it's easy. It's really easy because these wrap-up programs are so good. They set it up in a manner that everyone can understand what's happening, who's who, who's handling what, who you need to call when something happens. It's so easy to follow. The main parties in the wrap-up policy program are the broker, the insurance carrier, and the third-party administrator, or the TPA, the policy holder, the insured, the general contractor. So the broker is the firm. There are firms out there that do this. They're the ones that get the deal with the owner or the general contractor to put together this wrap-up policy. Keeping in mind that the insurance carrier doesn't put together the wrap-up program. They are only writing the insurance policy, right? So the broker is the one that's actually putting together the program. Some brokerage firms actually provide counseling and advice on risk in addition to just putting together the program. So they're more involved. They're usually very heavily involved, actually, involved to the point where they actually make decisions on how the cases are going to go. They actually provide authority for settlement, anything that we need, surveillance, and so forth. We've seen some brokerage firms actually provide those services to their clients. Now, when they have the program, an idea of what they're going to do, they start vetting insurance carriers to underwrite the policy, and then there's a third-party administrator. Now, something to know with the way wrap-ups work in general is that the owner or the general contractor would have a deductible up to a certain amount. In the construction cases, we usually see it up to $1 million, and that's why you need the insurance carrier beyond $1 million. And that's why you also see that within that first $1 million, the owner and the brokerage firm is making most of the decisions. When you go over deductible, that's when the carrier is more involved in the decision making. And then there is a TPA who administers the policy. The policy holder would be, let's say it's the owner would be the policy holder, and the insured would be the contractor that's being covered on the project. And general contractors come into play when it's a CSIP, when it's a contractor-controlled insurance program. The general contractor is the one that usually partners up with the brokerage firm to create this CSIP policy. So those are the main parties. The additional parties would be like the investigation company, then there's case manager, they like a special company to be on site for like on-site medic, provide medical treatments on site. There's usually like IME vendors also assigned to a particular program. There's a panel of them that would be assigned from the very beginning. There might also be preferred doctors that are selected to do certain kinds of IMEs that arise, or the need for which arise from construction claims. So everything's usually set up in the beginning, and we know who's who and who's going to be doing what. And the enrolled contractor, they're the insured. All right. Another complication is unfamiliarity with wrap-ups. This is something we see ever so often, almost in all of our cases, all of our denied cases where a coverage issue comes up. Both the claimants and the board are very unfamiliar with wrap-ups, right? Especially the claimants. A lot of them are just brought to the job site, do the work. They don't even know who their employer is. They just see someone wearing a shirt with John Smith Construction on it. And if an accident occurs, they say, well, that guy was telling me what to do when, when the accident happened. So I work for that company. And they certainly don't know, like, if it's a wrap-up or an operational policy that's in place, and rightfully so, right? That's not something that they're usually really attuned to. Even some of the supervisors, like the foreman or the superintendent, they sometimes don't know what kind of a policy covers the project. But interestingly, the board doesn't really always get what like a wrap-up is. And some of the things that we've seen is that the board doesn't understand like the parameters of a wrap-up. So we've had cases where it was clear that coverage doesn't belong with the policy I'm defending, the wrap-up I'm defending. But because the judge doesn't understand, like the terms of the policy and the parameters of the policy, it's like, all right, well, you had coverage from January 1st of 99 to January 1st of 2000, and the accident happened somewhere in between there, so you're going to be liable. I mean, on appeal, that's a winnable issue in appeal, but I feel like a lot of these appeals could be prevented if the judges were a little more familiar with the wrap-up policy. Our job, one of the things that we've been doing is trying to educate the board about how these work. We do this by presenting really lengthy arguments of the hearing, and then do written summations ahead of time just so everyone can read them and really understand what's happening. We've seen them getting better, but it's still an issue that we see that's really forcing us to keep filing appeals in certain cases. It leads to the wrong carriers being placed in notice. I currently have an ongoing coverage issue where there are 12 carriers being placed in notice. My client is clearly not liable. I've been arguing it at the last 2 or 3 hearings. We've presented all the documents, and because the judge just doesn't want to deal with it, she says, well, we're going to put it off until further development of the record. I'm not discharging or releasing anyone from notice at this point. And I think it's just because of her unfamiliarity with the program and the policy, and she doesn't want to make any decisions before the record's complete, even though it's really complete with just the policy documents that we submitted. And what happens? We've seen cases dragging out. We've seen 5, 6, 7 hearings. A year later, we're still talking about coverage. It's frustrating for us because our clients' resources are being used up, actually wasted, by us keeping on going to these hearings. And then the clients, the claimants, most of them have legitimate injuries, and they're just waiting for the proper carrier to be like placed in notice so they can, start getting the treatment they need and so forth. So it's really like a disadvantage to them also. And I'm hopeful that one day the board's really going to start understanding how these wrap-ups work and more efficiently make decisions on coverage. All right, guys, so that's all I have for today. I just wanted it to be a brief overview of wrap-ups, aka OSIPs and CSIPs. If you have any questions, type them into the box on your screen. They'll pop up on my end. I'll provide the answers. If I run out of time, I'll be sure to email you the answers. As you know, I do this webinar every month. It's the first Monday of the month. The next one's going to be May 4th. And we're going to talk about preparing for the loss under a wrap-up program. We're going to talk about everything that needs to be done and how it can make our lives easier and how it can make defending these cases, easy breezy. All right, so I will check for the questions now. Let me see. Oh, all right. I don't have any questions, and I'm hoping it's just because there's a technical glitch and your questions didn't show up in my end, but they're going to pop up in my email box later, right? or maybe my presentation was just so good you have no questions. Anyway, if you think of anything, feel free to give me a call or send me an email. All of my information is on the registration that you did for the webinar. I did get some requests from some of you for specific topics that I'm going to be covering in the second half of the year. I'm still taking requests or recommendations. If there's a particular kind of particular topic that you'd like to see me cover, send me an email, give me a call, and I am going to either incorporate it into one of my webinars, or I can do like a special webinar. It can be anything that's construction related, or even if there's anything just workers' compensation related. I did get a request to do the Kelly Burns calculation. I know this one always gets her head spinning. So I'll be doing that in one of the later webinars. When the reminders go out, you'll know which one it is. But I will hope that you're going to continue to join me for every webinar for the rest of the year. All right, everyone, thanks for joining. I'll see you next month.